welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the nation. Here are the headlines. Supreme Court soon to examine the constitutional validity of Section 6A of Citizenship Act relating to Assam immigrants. Governors must act on bills before the matter comes to Supreme Court, says CJI while seeking an updated action taken report in Punjab Government's plea against Governor. Supreme Court dismisses PFIs petition against UAPA Tribunal order confirming a 5-year ban on it by Centre. Tejaswi Yadav approaches Supreme Court seeking transfer of defamation case against him from Ahmedabad to Patna. Madras High Court cautions against dangers of fissiparous tendencies by persons in power after the Sanatana Dharma Hate Speech incident. Delhi High Court directs state government and MCD to comply with Manual Scavenging rules. Now let's take a detailed look on the headlines. The Supreme Court today said that it will commence from December 5th the hearing of petition to examine the constitutional validity of Section 6A of the Citizenship Act, which relates to the illegal immigrants of Assam. The said provisions directs the registration of residents of Assam under Section 18 of the Citizenship Act if they fall under a specified category. The matter was scheduled to be heard by a 5-judge constitution bench of the Supreme Court starting tomorrow. However, it has been adjourned and will now be heard starting December 5th. The matter was deferred by a bench headed by the Chief Justice of India D.Y. Chandrachud after it was mentioned by the Solicitor General Tushar Mehta. Section 6A was inserted in the Citizenship Act as a special provision to deal with citizenship of people covered under the Assam Accord. The provision stipulates that individuals who arrived in Assam from specified territories, including Bangladesh, between January 1, 1966 and March 25, 1971, as per the 1985 amendment made to the Citizenship Act, are required to undergo a registration process to obtain citizenship of India. The provision thus makes 25th March 1971 the cutoff date for granting citizenship to migrants in Assam. Addressing the ongoing feud between the Aam Aadmi Party-led state government of Punjab and the Governor Banwari Lal Purohit, the Chief Justice of India sought an updated action taken report in a plea filed by the state government against the governor for alleged delaying in giving assent to bills proposed by it. Solicitor General Tushar Mehta appeared for the Punjab Governor and informed the bench that the governor has taken action on bills placed before him, and the plea filed by the Punjab government was in fact an unnecessary litigation. The top court's bench headed by the CJI D.Y. Chandrachud and also comprising Justice J.B. Pardiwala and Justice Manoj Mishra scheduled the matter for hearing on November 10th and said that governors must act even before the matter comes to the Supreme Court. A little bit of soul searching is needed by governors, and they must know that they are not elected representatives of people. The feud between the Punjab government led by the Chief Minister Bhagwant Mann and the Governor Purohit began on November 1st, when after giving approval to 2 of the 3 bills sent to him, he wrote to the CM, stating that he would examine all the proposed laws on merit before allowing them to be tabled in the State Assembly. It is pertinent to note that the approval of the governor is required to table money bills in the House. Previously in October, the governor had withheld his approval to 3 money bills, namely the Punjab Fiscal Responsibility and Budget Management Amendment Bill of 2023, the Punjab Goods and Services Tax Amendment Bill of 2023, and the Indian Stamp Punjab Amendment Bill of 2023, which were to be tabled in the Assembly during the October 2021 session. Governor Purohit had also said that the October session, which was intended to be an extension of the budget session, would be considered illegal and in violation of law, and any business conducted during it unlawful. On account of this, the Punjab government had cut short its 2-day session. The Supreme Court today dismissed the plea filed by the Popular Front of India against the Unlawful Activities Prevention Act Tribunal that confirmed a 5-year ban imposed on it by the central government, while allowing the banned organization to approach the High Court in this regard. The plea came for hearing before a bench of Justice Aniruddha Bose and Justice Bela M. Trivedi, who said that it would be appropriate for the PFI to first approach the High Court against the order of the tribunal. The petition by PFI challenged the UAPA Tribunal's order dated March 21st, which confirmed the decision of the central government made on September 27, 2022. The organization was banned for 5 years for its alleged link with global terrorist organizations, including ISIS, and trying to create communal hatred in the nation. The Deputy Chief Minister of Bihar, Tejaswi Yadav, has approached the Supreme Court seeking the transfer of a criminal defamation case against him for his alleged remark, "Only Gujaratis can be thugs." Tejaswi sought the transfer from Ahmedabad to Patna, which is the place of his residence. He also sought exemption from appearance in the court of Additional Metropolitan Magistrate D.J. Parmar of Savarkundla in Gujarat, which summoned Yadav on September 22nd. Yadav relied on the ground that he has filed an application under Section 406 of the Code of Criminal Procedure before the Apex Court for transfer of the case, and the matter is likely to be heard by the top court on November 6th. Pulling up the state police for their failure to take action against the ruling party and ministers who participated in the Sanatana Dharma Eradication Conference held in Chennai in September this year. Justice G. Jayachandran of the Madras High Court made some interesting observations. Justice Jayachandran said that persons in power should realize the danger of speech with fissiparous tendency and behave responsibly and restrain themselves from propagating views which will divide people in the name of ideology, caste and religion. The observations were made by the High Court while it dismissed a petition seeking a direction to the police to permit him to conduct a conference for eradicating Dravidian ideology and coordinating Tamils. The petition was filed in the wake of the Sanatana Dharma Eradication Conference that for long has been a controversial issue, after several influential persons made derogatory remarks against the Sanatana Dharma, including Udayanidhi Stalin, who is the state minister and son of the chief minister M.K. Stalin, and A. Raja, among others. The court said, due to the police's failure to take action against persons who made inflammatory remarks against Sanatana Dharma, there is now a plea seeking permission to host a conference to counter Dravidian ideology. The court further observed that granting permission to such a meeting would further disrupt public peace and tranquility. Hence, the court cannot allow the petitioner to conduct such a conference. A division bench of the Delhi High Court, headed by the Chief Justice Satish Chandra Sharma and also comprising Justice Tushar Rao Gedela, directed the state government and the civic authority, Municipal Corporation of Delhi, to comply with the rules for manual scavenging. The High Court, while hearing a batch of petitions seeking strict implementation of the provisions of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act of 2013, issued directions for the authority to strictly implement the judgment passed by the Supreme Court in this regard, to eradicate manual scavenging. Notably, the Supreme Court in 2014, in the case of Safai Karmchari Andolan and others versus Union of India, has dealt with the provisions of this 2013 Act and issued directions for aiding financial, educational assistance along with subsidies to help the manual scavengers to opt for an alternative occupation. In February this year, the top court again emphasized on the need for effective implementation of provisions of employment of manual scavengers and construction of dry latrines Prohibition Act of 1993, along with the PEMSR Act of 2013. Taking into account the Supreme Court's order, the High Court noted that after the ruling by the Apex Court, a blanket ban has been imposed upon manual scavenging, and no further orders were required to be passed in the present case. The Delhi High Court, after making the observation, disposed of the case. That was all on today's legal news. Thank you and keep watching Verdictum. And subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.